And we meet again. Yeah, this is Rob Ryder. Video on a bunch of little things that probably end up being a fairly long video, so you may want to stop now and go grab a beverage and turn off the stove. Well, whatever you need to do. But lots of little things that need to be talked about, and I just put them all on one. So, kind of the things that this video is going to be about is the right to bear arms, or what's your sign? Because right to bear arms has nothing to do with a instrument that shoots lead out the end of a barrel. Infants as parties to deeds. What did you get yourself into? What did I get myself into? How do we get ourselves out of it? All infants' deeds are void or voidable. It used to be infants couldn't be made parties to a deed, and at one point they decided they could, but they did say they are void or voidable. What's in a street name? One of the crazy things that could be in a street name is your securities. What does Grand Rapids, Michigan, Geneva, Illinois, Detroit, Chicago, London have in common? Well, they've all had a fire. Burnt down a courthouse. Or at least part of it. Land registration. Stationary and movable. Yes, I have seen something talking about movable land before. Go figure. Wonder what that might be. Wonder when an earthen vessel could be considered movable land. Wonder if your body could be considered an earthen vessel. I wonder if they could be registered like ships on the sea. I believe they have been. And this is Monday, January 20th, 2014. Our power player of the day is the state of North Carolina, where every 4 years, voters of each county in the state of North Carolina elect a clerk of the Superior Court. Honorable Archie L. Smith III was elected clerk of the Superior Court of Dunham County in 2002. Still there, because I took this off the website, so he's been there a while. And he went to Chapel Hill and got his Bachelor of Arts, graduated North Carolina Central University School of Law, practiced in Dunham County for more than 26 years. As the office of clerk of the Superior Court is both an administrative and judicial office. As ex officio, judge of probate, the clerk of the Superior Court has exclusive original jurisdiction over matters relating to probate of wills, administration of estates, of decedents, minors, and incompetents. He's a judge of probate. I wonder if he can issue a warrant. I wonder if he can take your complaint. I wonder if he can go get you the record to your property. I wonder if he can get you the record to your body, to your all caps, to your estate. I think he can. And donate. Hey, if you could, it'd be wonderful. It's getting close to the end of the month again. And no, I cannot pay my rent. The PayPal account is ashleyrytlewski@gmail.com. ASHLEYRYTLEWSKI@gmail.com, or Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. My email is courtofrecord@AOL.com, and you should send me an email to be added to the list of those who receive these video handouts, the shit that I show on a video that I put together in an email when I send the email out to say, hey, I did a video. Because I don't like people to call me later and say, hey, can you send me the stuff that was on a video? Because I don't know, I'm going to have it. I won't be able to find it in a week. And my phone is 616-719-6179. And I will be biting on a candy while we're talking. I got kind of an itch in my throat. You have to forgive me. But we got lots to cover. Now, where to start? I think we're going to start with what does Grand Rapids, Michigan, Geneva, Detroit, Chicago, London have in common? Well, again, they've all had a loss or destruction of public records, most of them by fire. So this is the Michigan compiled laws. You could find this easily by going to Google and putting in MCL 461.2 and go to the legislative site. Just follow the links. or MCL 461, put it in, because this is one part of the act, but I don't necessarily going to put them all up here. What does Section 2 have to say? When the public records in the Office of the Register of Deeds of any county have been or shall hereafter be lost or destroyed in whole or in any material part, if any one of them happens, by fire, flood, or other disaster, the Circuit Court and Chancery, now again, we're not supposed to have Chancery courts, but there it is, the Circuit Court and Chancery. Don't let them tell you it doesn't exist. There is a Chancery Court, or the Circuit Court has the powers of Chancery. For any such county shall have jurisdiction and authority to hear and determine any suit instituted under the provisions of this act and the rights of the several parties in said suit. And it shall be the duty of the prosecuting attorney of each county, when directed by the Board of Supervisors of such county. So when the board tells the prosecutor of the county to, hey, why don't you file a bill in Chancery on behalf of the people of the state of Michigan and of the county to determine and quiet title in and to the lands in such county. So we had a fire, burnt some records. We don't know whose is whose. We're going to put in a bill in Chancery on behalf of the people, the public, and of the county. Now the county isn't the people, right? The county is a municipality. They got a corporate charter. It's its own entity. It's its own people. Its own person. So we're going to file a bill in Chancery. The defendants in which shall be described as all persons having or claiming any interest in or lien upon the real property herein described, or any part thereof. So, your Board of Supervisors is, because, they had a little fire, not really sure what records got destroyed. Instead of looking real close, we'll just put in a bill of Chancery and say, hey, we had a fire. Make everybody defendants. Make the plaintiffs the people of the state of Michigan, being the public, right, the state, and the county is his own person. All right, they're the plaintiffs. Or they're the petitioner and we're the respondents. We really shouldn't be defendants yet. It's a bill in Chancery. It's a bill of complaint. Well, I guess I don't know if it's a bill of complaint. It's just a bill in Chancery. We have to find out what kind of bill it is. Oh, there it is. The bill of complaint. Well, on a complaint, there's complainant and respondent. That's, Anyways, a bill of complaint shall contain an allegation setting forth that all or a material part of the public records in the Office of Register of Deeds of the county have been lost, destroyed by fire, flood, or other disaster, man-made disaster. The fire that happened in Geneva, Illinois, at the courthouse happened because the lawyers were having a party, and during the party a fire got started. And all the records except the tax records got burnt up. Go figure. And the property rights of the state of Michigan as political subdivisions and private citizens have been impaired thereby, and shall describe all real property in said county affected by said loss. Real property in the county shall be sufficiently described by giving the name of the county and describing the territory including therein at the time of the destruction of the records, by using the same description set forth in the act or acts of the legislature organizing and assigning territory to such county, or the applicable parts thereof. The court shall have jurisdiction over all real property affected by the loss and destruction of the records of the Register of Deeds. In case the entire records of the Office of the Register of Deeds have been lost and destroyed, the Circuit Court shall take judicial notice thereof. Well, the court's going to take jurisdiction, and they're going to describe it with some archaic bullshit that we didn't know in the first place, right? However it was done in the acts of the legislature that organized the damn territories. Upon the filing of a bill of complaint, the Circuit Court shall enter an order for appearance and fix a time and place for a hearing. Now remember, they made you a defendant, so they're telling you, hey, owner, you need to come to court. Said order shall be deemed sufficient for the purpose of this act if the persons ordered to appear are described as all persons having or claiming an interest in or lien upon property described in the bill of complaint, including their unknown heirs, devisees, legates, and assigns, as the case may be, and setting out the same description of real property as contained in the bill of complaint. So they're going to have this and then a bunch of gobbledygook afterwards, right? Ranges and sections and who knows? Who knows how they got it? You have to go see what the bill of complaint looked like. The court may direct that the order for appearance shall include additional descriptions by name or otherwise of territory within the county, including without describing the several pieces of parcels thereof, the several townships by name, the sections thereof by number, and the names of cities and villages, and recorded plats, subdivisions outside the cities. Right? All sorts of ways they could describe it. Provided, however, that no matter how they do it, the court has jurisdiction over the property. Such order for appearance shall be published for 6 consecutive weeks, at least once a week, in a newspaper published in the county where the real estate is located, if there be one. And if no newspaper be published in the county, then such order for appearance shall be published in a newspaper published in an adjacent county, and in every case within 30 days after the first publication of such order for appearance, a true copy shall be posted in a conspicuous place on the building in which the circuit court is sitting. Okay, where's the circuit court sitting? That's a good question. The circuit judge may order such additional publications as the court shall deem necessary to give reasonable notice of the pendency, lis pendens, of such suit. The court may order that printed copies of the order for appearance be furnished to the supervisor of each township for distribution to the residents thereof, and may order that copies thereof be posted in conspicuous places, yada yada. He may do all these things, and then again he may not do a damn thing. Where persons assembled and copies mailed to all persons within the county having a post office address. There it is, post office address. What is a post office address? Is that different than a mailing address? Different than your street address? Different than a physical location? Different than a business address? Yeah, well, have a post office address. If you got one, hey, they may have sent it to you. I think we have post office addresses. They just haven't been assigned to us yet. When we get our post office address, all the mail that we haven't seen will start coming to us. Okay, after the expiration of 90 days from the date of said order, upon proof of publication provided by the foregoing paragraph, the court, on the date set hearing, or the adjourned date therefor, and upon hearing and proof thereof, shall enter a decree, which shall state that the records in the office of registered deeds have been lost or destroyed in whole or in any part material by fire, flood, or other disaster, and shall authorize the filing of intervening petitions as provided in Section 5, and issuance of order based on testimony introduced under Section 5 and 6 of this Act, determining the interest and title to the particular parcels of land. The decree shall further provide that all persons entering appearances before the issuance of such decree shall be served personally or by registered mail. Right, if you've entered an appearance by any petitioner, any other proceedings hereafter instituted under Section 5, yada yada yada. The said decree shall further provide that all such appearances entered shall be recorded by the Register of Deeds, and a reference to the book and page entered upon the map provided for in Section 8 of this Act. The court authorizes to issue such further orders as it is deemed necessary. Well, so what what do they do? Had a fire, maybe put something in the paper, maybe really tried to tell people, put a bill in a chancery in the name of the state of the people of the state of Michigan, the public, right? So that's for the state and the county. It has nothing to do with the people or individuals in the county. It's for the county, because the county is a political subdivision, to determine quiet title in and to the lands in such county. So if you don't show up to defend your title, you're going to lose your title. Okay, so this is Section 5. Any person having an interest in or lien upon any parcel or parcels of land conveyed by said bill of complaint may at any time intervene in said proceedings. So here's the thing, okay? That's what they did before. This is what we could do now, because it just said at any time. So if you have interest in some property in a county at any time, like now, right? So any person having an interest in or lien upon any parcel or parcels of land covered by said bill of complaint may at any time intervene in said proceedings and petition the circuit court to establish his interest therein or lien thereon, and said circuit court shall have jurisdiction to hear and determine such interest or lien and determine the interest of the claims adverse thereto. If you think you have interest in the property, so let's think about this further. Okay, you actually own property, but what if there's a bunch of empty houses right now in some property because we have all these foreclosures and stuff? Well, what do they do up here? This was made out on behalf of the people of the state of Michigan. Well, you're one of the people. You have an interest. Tell them as one of the people you have an interest in this empty house, and if nobody else is claiming it, you're going to. Okay, at any time. Service of summons issued under said intervening petition shall be made personally by registered mail on any person or persons known to have an interest in any of the parcels of land in said intervening petition, and service as to persons unknown shall be deemed to have been made by the general publication provided in section 2 or 3. So, you got to send it to the people you know that do, and for those that you don't know, then you put it in the newspaper within the county for 6 weeks, like it, whatever is set up here. Yeah. Well, anyways, you can go back and read it yourself. I can't find it right now, but you get the idea. You're going to do whatever they did in sections 2 and 3. You're going to do it yourself. The intervening petition shall be sworn to by the moving party, his agent or attorney, and shall state that the offendant does not know and has been unable, after diligent search and inquiry, to ascertain the names of the persons who are included as defendants thereon without being named. Okay, so you go in as one of the people, and you go to look at, whenever this happened is when they did this. So when was the fire, right? All them people are dead anyways, so not going to be able to find any of them. You have to think about it. How are you, if you don't really have any interest in it, going to show you have interest? That's for those of you who are trying to get an empty house. Say, hey, Bob, how do you do this? I don't really know, but you may want to go try this. But let's say you're living in a house right now and you have a warranty deed, and on that warranty deed you are an assignee from the original land patent, because that has a physical description or a description on it. So you want to go and find out by doing this petition to have the land put in your name. Because right now I don't believe it is in your name, because what I'm thinking probably happened, they had this fire, nobody shows up, all the land goes back to the state and the county, and you become, when you're in there, you become a joint tenant. You don't get it in fee simple, although you should be getting it in fee simple. Provided, however, that as to lands, the title of which their heretofore and hereafter has vested in the state of Michigan by reasons of tax reversion under the provisions of something else, no affidavit of search or inquiry as to parties in interest prior to the vesting of title in the state shall be required. Oh, so you didn't pay your taxes, it's going to the state anyways. All persons other than the intervening petitioner, that's why we have a state land bank. That's where all the land is being stashed at right now. All persons other than the intervening petitioner in actual possession of land included within the claim under the intervening petition shall be served with a copy of the summons under the section and the personal service obtained upon such person Okay, so if there's somebody in the house right now, you'd have to send something to them. Who's in possession of the house? Or possession of land? The summons to be used under this act shall be substantially in the following form. State of Michigan, in the circuit court for the county of, in Chancery. That's very important. That's how it's the proper address of the circuit court in a particular county in Chancery for you to put in a petition for equitable remedy. Because it's the court of Chancery that can offer all the different injunctions, subpoenas, the original writs under the Great Seal. All that shit happens out of Chancery. Courts of law only have one remedy: damages, money. And a lot of times we're not after money, we're after property. Right? I want the bag, I want the box, I want the truck, I want whatever it is. It's mine. Whatever's in it is mine. It's none of your business what's in it. The box is mine, and so are its contents. Right? I don't want money, I want the box. And in the box may be money. But, I don't want the money, I want the box and its contents. And for those type of things, you need to go to the Court of Chancery. Well, in Michigan, if you want to know how to address the court, State of Michigan, in the circuit court for the county of, in Michigan, petitioner, all persons claiming any interest, yada, 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 defendants, petition filed, date. Anyways, this is easier to read if you just go to MCL 561.5, put that into Google, and you can see what this looks like. I'm not going to read the whole thing. At the end of the day, I'm mainly showing it right now to point out the fact that there is in the circuit court for the county of, in Chancery. And you would take this petition to the court administrator, not the court clerk that we think of, to the court administrator. Okay. Plaintiff file with clerk of the above entitled court and county within 3 months after the date of filing noted above, and set forth the interest or lien, in if any, you have in upon certain real property, part thereof situated in the township of, county of, or the city or the county, State of Michigan, particularly described as follows. Yada, yada, yada. After 3 years from entering of decree provided for in Section 2 of this Act, and no petition having been filed under Section 5 of this Act, with respect to any particular parcel of land which is or may be owned by the state or any agency or political subdivision thereof, the circuit court may, on its own motion or motion of the prosecuting attorney, determine interest in or title to any parcel of land not covered by any decree or order of the court. So, nobody showed up. The court can give the property to the county, the political subdivision, the state. Now they're going to figure out how they're going to handle it. It shall be the duty of the prosecuting attorney to furnish the court with such evidence as shall be available. The prosecuting attorney shall serve personally or be by registered mail all parties of interest as shown by the public records. Court's jurisdiction, the circuit court in Chancery shall have jurisdiction to determine interest or title to any parcel of land, whether the person entitled to such decree is in possession or not. This is why, forgetting everything else we've been talking about up till now, this right here, you go to the circuit court in Chancery, which is the court administrator, with your warranty deed and say, hey, I'm the owner. I should be the rightful proprietor, and I should have fee simple title. But the title insurance companies refuse to defend my title, and I don't have fee simple. What are we going to do about it? I've come to you for justice. I demand the king's peace. My peace is being disturbed because of robbers, thieves, and crooks. The original certified copy of all decrees, orders determining interest or title to any parcel of land shall be filed with and shall be recorded without charge by the Register of Deeds. So you get this Court of Chancery to give you a certificate and you take it down to Register of Deeds, and they're going to put it in there for free. Said Register of Deeds shall record the same in a separate book kept for that purpose, and shall also enter on a map or plat kept for that purpose a reference to the book and page wherein is recorded such decree or decree. So these decrees and so forth are recorded on a map that's been kept for that purpose. There's one place to start. Register of Deeds got a map. They had a fire, and they're supposed to put all these decrees and list them on there. You know, but I don't want to mess with Register of Deeds. I want to go to the clerk and say, hey, I got a warranty deed, says it's my property. What I don't have is the title. So I need you to quiet the title, right? Everybody wants to quiet the title. Well, go to the Circuit Court and Chancery because they have the jurisdiction to determine the interest or title to any parcel of land, whether the person is entitled to such decree is in possession or not. No fee shall be charged by the Circuit Court as condition to filing of a petition in any proceeding instituted under this provision of this Act. So, anyways, there you go, right? You have a fire, you get rid of the records, you put something in the paper, said, hey, we're going to have to, start over from scratch here. If you think you got interest, come on in and we have to have a hearing. You got to put in a petition into some obscure paper using some legalese that nobody is familiar with to describe the property they're talking about. In 1844, in 1944, during World War II, in the first extra session when they passed this thing, and the next day they're out doing it, right? So we're in the middle of a war. It's a good time to put this in. There won't be anybody paying attention. Right? All that they put in the newspaper was war stuff. Well, they probably had a ration on paper, right? So it showed up very few places. Okay. So that was loss or destruction of public records. MCL 461.2. I'm sure that your state has a Loss or Destruction of Public Records Act also. You don't need to look at Michigan's. I use Michigan's because it's where I am, right? But although everything is different, it's all the same. You're going to have something similar to this in your state. Okay. Now what? Land registration. Come on, book. Okay, if you go to archive, archive.org, and put in land registration in Illinois, it's really all you need to put in, because this will be like the first hit by Theodore Sheldon. It's a book that's about land registration in Illinois. Imagine that. And Illinois was the first state to adopt this. I'm not going to read this whole book, of course, but I just want to point out a few things. That what this is, to consider whether the Australian or Torrens system of registration of titles could be adapted to the constitutional laws of the state. The Torrens system was originally set up to register ships, and it was adapted by, I think 19 states at one time went to the Torrens system. So they say. I don't know if more have or not, but as far as I think they have, but not necessarily for what we would call real estate or fixed land. I think for the movable land, your body, they did, and I think for vehicles they did, and lots of other things they went to the Torrens system. And So we're just going to see what this thing did real quick. Okay, the recorder of deeds is made register of titles, and in addition, so the recorder of deeds is made registrar of titles. Who's the recorder of deeds? In addition to his duties as recorder, conducts the registration of titles and all dealings with registered land. He is assisted by deputies in examining the title, the later attorneys at law. Initial registration. It is optional with the owner of to register his land. He files in court of competent jurisdiction his application in writing for the registration of his title. This is ordinary case may be in the following form. So first thing is, registration of land is voluntary. You should be able to unregister your land. Chances are it's registered right now. To the judges in the Circuit Court of Cook County in Chancery sitting. That's how you address the Chancery Court in Illinois, right? At least for Cook County. To the judges of the Circuit Court of whatever the county is, comma, in Chancery sitting. This is a petition going to them. Or make an application to have registered the title of the land hereafter described. Do solemnly swear. The answers the questions, yada yada yada. Okay, so this is what they had to do. I mean, this is how you registered your land voluntarily. Now in England, they make it voluntarily. So if you want to sell the land, you're going to have to register it first. Okay, so. Okay, let's see where we're going to start here. He approves no title unless satisfied that all persons interested are before the court. If in his opinion the applicant is entitled to register, he so reports to the court. To the report of the examiner, any party may file objections which are heard and disposed of by the court. Upon the confirmation of the report, a decree is entered confirming the applicant's title and directing the registrar to issue to him the first certificate of title. This is done by entry in a book called the Register of Titles. This book is composed of a large number of certificates of title, one on a page, bound together, numbered in the order of their issue, and each with ample space at its foot for entry of subsequent notations affecting the title. So once this thing is in the book, it's got room at the bottom, and if there's a lien or something put on the property, it's supposed to go on this title page. Every certificate of title is in duplicate, signed by the registrar, and recites the condition of the title. One of these is kept by the register, bound in the Register of Titles. The other delivered to the owner. So one, the original, is put in this Register of Titles book, and the other one is given to the owner. It's called the owner's certificate of title. This completes the initial registration. The certificate of title, immediately upon issue, is conclusive proof of ownership in all courts against all parties before the court in the proceeding for initial registration, and all persons dealing with the land after registration. So, if you're in a state that uses the Torrens system, and you've gone and bought property, do you have a certificate of title with your name on it? If not, you don't have conclusive evidence. After expiration of 2 years from the first registration, no suit attacking the title of the registered owner can be brought. No exception is made in favor of infants or persons under disability, but such persons are given recourse upon the indemnity fund. It is thus seen that all persons are bound by first certificate of title except those overlooked and not made parties to the suit for registration. If the court proceeding is properly conducted, there should be no person not bound by the first certificate of title. Alright, so once this first one's in place, boom, the right system's ready to roll. In all dealings with land after registration, The bona fide purchaser or encumbrance have a like security to that given to purchasers of negotiable paper. The title of such purchase or encumbrancer cannot be upset. Transfers of registered land are made in the following manner. The owner executes the usual deed and submits it together with his certificate of title to the buyer. Remember, the owner got a copy, owner's copy of the title, and now he's going to write a deed, which is a contract to convey the property. In every transaction, the owner must produce his duplicate certificate of title. So, did the owner, the grantor of the property, when you went to buy the property, did he give you his copy, show you his owner's certificate of title? I doubt it. He can do absolutely nothing without it. He can't sell it to you unless he has it. If lost or destroyed upon proper showing, the owner receives a certified copy marked owner's certified copy, issued in a place of duplicate lost. This, after entry of transaction upon original certificate of title, answers the same purpose as the lost certificate. No new forms of conveyances are required. The buyer, after inspection of the original certificate of title in the registrar, so now the buyer, you, say you're buying property, you got the deed, and you're supposed to have the owner's copy, but you don't have it. But nevertheless, the original is supposed to be in the register. The buyer, after inspection of the original certificate of title in the register and finding thereon no encumbrances or lien, safely pays over the purchase money and receives the deed and duplicate certificate of title. So you're supposed to go to the original at the recorder's office, because on there, if there's any liens or encumbrances against the property, it's going to be annotated on this original certificate of title. Did you do that? Nope. And okay, so then but let's say you had, right? And now you pay over the money and you get the copy of the warranty deed or the deed, whatever it would be. This doesn't say warranty deed, now does it? It just says deed. And duplicate certificate of title. You, the buyer, then delivers both of these to the registrar, who when satisfied as to the identity of the parties and that the transfer should be made, notes the transfer upon the register. This operates to transfer the title. No title passes by delivery of the deed. The deed after delivery and before registration of the transfer is a mere contract between the parties. That's what the warranty deed is supposed to be. It's a purchase contract between you and the grantor. However, the way it's written, it's actually an implied trust, and you as the grantee are a grantee in trust, holding the property in trust for an unknown beneficiary, who's the guy who put up the $10, your joint tenant. Its sole object is authorized register. Okay, the deed, its contract. Its sole object is to authorize the registrar to register the transfer. The transfer is registered when the registrar cancels the old certificate of title and issues a new one in duplicate as before, one called the original, being retained in the registrar, and the other called the duplicate or the owner certificate, after proper receipt thereof, filed with the registrar, delivered to the buyer. Now the new owner, the deed is kept by the registrar. You're going to walk in with the old owner's certificate of title and the deed to the registrar. You're going to walk out with your owner's certificate of title. She's keeping the deed and the old certificate of title and going to change the one in the original that's in the record to show that you're the owner. So there's this file of these owners, or these original certificate of title. This is Illinois. And in there, again, 19 states use this. I don't know how many other ones may have used something similar. But in there is supposed to be where this thing is listed. And if you find the original and go and look at it, it will have all the different liens and encumbrances that are on your property annotated. And it may just be a file number, and you need to go to that file to find the actual encumbrance. Now, This is for states that have the Torrens system, the certificate of title. It's the same thing with an abstracted title. It's really the same thing. I don't really know that there is any difference, but they got different names, right? Because they can't call everything the same thing. It'd make it too easy to figure out. So, anyways, it's kind of how that works with the registration of land. So that's for fixed land. Now, strange as it may be, or may seem, I'm thinking that this right here is my owner's certificate of title to, all caps, my estate. This is a certified copy of record of birth, State of Michigan, County of Bay. I, Stephen Toth, Clerk of the County of Bay and the Circuit Court thereof, the same being a court of record, having a seal, do hereby certify the following is a copy of the record of birth of, all caps, now remaining in my office, and the whole thereof, viz. Child. And there's a record, 2137, in Liber F, page 2137, date recorded. So, look at this seal here. It's Circuit Court of Bay County, Michigan. Not the 18th Circuit Court, or whatever the number is. This is the Circuit Court of Bay County, Michigan. So I've taken this thing before. As you can see, I've had it recorded a couple times. I put it in the Register of Deeds in 2 different counties, and I actually sent this to probate of Bay County, to the probate court, to the probate registrar, who called me. This was a couple years ago now, and asked what I was trying to do. And I said, well, I believe that there is a deed referenced on this document. I'm trying to get a copy of the deed. He said, oh, you're looking for a deed. Let me transfer you to the Register of Deeds. At the time I said, okay, well, why not? But the Register of Deeds didn't want to talk to me. Like everything else, at the time it's like, well, what do you do next, right? You're not trying to cause a controversy and trying to get this thing settled. Let me think about it some more, and next thing you know, you're getting calls about this, that, and the other thing, and boom, it's been a year, you haven't done anything with it. It's been a couple of years. But I didn't know until just recently that, hey, there's this office called the Court Administrator, which is the CEO of the court. And this is talking about a record. I'm really not talking about a deed. It says record number. And like Xavier found out on Friday, when he was trying to find out about a foreclosure, and if you had the Liz pendants where he could find the certificate of pendency and the rest of the foreclosure file, and the Register of Deeds, not the Register of Deeds, excuse me, the court administrator told him, well, do you have a copy of the Liz pendants? He said, no. He said, well, you'd have to get that and find out what court it is, and then go there and order a copy of the record. Now, other people I've talked to or have heard on stories, right, they've gone like to the vital statistics or whatever and tried to get their birth records, and they've been told, well, we need a court order. Well, I think the person that can give you the court order is the court administrator, because they can issue process. And so I'm going to send this to the court administrator of the birth county and say I would like to order a copy of record 2137, Liber F, page number 2137, da-da-da-da-da. Because in this record, I believe we're going to find the infant deed that we've been made a party to. And it's never been read to us, and it has a few things that we need to do to claim our estate. So I think that this is the owner's certificate of title, that there's one like this, the original certificate of title. And then there's the actual title, the record, somewhere else. Right? Just like it was reading in the Torrens book there, that you got a title, the title goes in a drawer, and they issue these two pieces of paper. One's called the original certificate of title, and the other one's called the copy of the owner's copy, I guess. So, certified copy of record of birth. And there's going to be another one like this in the drawer, and it's going to reference this book, page, whatever, and you can go to that and find the information for the birth record. My opinion. There's a big gold seal, too. It's nice and gold. See, and this says I, Stephen Toth, all caps, right? This is his legal personality. And, excuse me, it's his business name. And somebody else could be doing business under his name, right? There could be lots of people doing business under a business name. Have lots of different owners. Because I think that Stephen Toth, see here he is down here again too, uppercase, county clerk. Problem with Stephen Toth is he has some kind of disability. He has a legal disability. And this Mary B. Fick, deputy clerk, actually is the power player in the court or in the building. Because they're going to be appointed by the judge. But the reason to go to the court administrator is anything to do with the court. If the court administrator is the chief executive officer of the court, then they know everybody's function within the court. So let's go there and let the shit roll downhill. So, yeah. I'm kind of thinking. Jurisdiction and venue. Oh, this goes with that North Carolina guy. This North Carolina. The clerk of the Superior Court's jurisdiction. Original jurisdiction. The clerk of the Superior Court has original jurisdiction, and in most cases original exclusive jurisdiction over legal proceedings to appoint guardians for incapacitated adults pursuant to something. The clerk also has original jurisdictions over proceedings to restore the capacity of an incapacitated ward, to appoint an auxiliary guardian, to remove guardians, to appoint successor guardians, to adjust the amount of the guardian's bond, to determine disputes between guardians, to ensure compliance with the court's orders and statutory requirements related to the guardianship of an incapacitated person. Right now, you're an incapacitated person. We got some kind of defect. We're an incapacitated ward. And the clerk has original and usually exclusive jurisdiction. And they can appoint the guardians. Well, that appointing the guardian is the ecclesiastic part of a probate court. There were certain things that when they made this other probate court that we're used to seeing, and they gave them like the administrative functions, just like the Supreme Court or the Circuit Court has done. But there's still somebody over on the judicial side, and that's who this is. And the ecclesiastic portion of the probate court, which goes back hundreds of years, it's a court of proof, that was handled differently. So, if they could appoint guardians, they were the true probate court. So this guy is like he's like a bishop, ecclesiastic bishop. Well, anyways, this just all this thing here is the jurisdiction and venue for these different offices in the courts, and you could find a copy of this if you so desire to find it by simply putting "the clerk of the Superior Court has original jurisdiction" into Google. Look, you can even I can, because I have it down here. Put it into Google and it'll show up in the first couple of pages. It'll say subject matter jurisdiction. So, because again, some people want these things and I don't send them after I've sent out a video. I may send them with the video if I remember to, but they're not that hard to find. If you really want to find it, it's online. Except for this. Okay, what we got left? Okay. All right, we talked about the infant deed. What happened there? The land registration. Power player. Okay, what we got left? I'm going to have right to bear arms. What is your sign? And what is in a street name? So let's start with just the definitions of name. A person's name consists of one or more Christian or given names and one surname or family name. So surname or and family names are different. It is the distinctive characterization in words by which one is known and distinguished from others. And description or abbreviation is not the equivalent of a name. Alright, so just your initials isn't the equivalent of a name. So this goes back to the video I did yesterday and shows where the officer is supposed to sign his name, right? You can't put your initial, you got to put your name. Distinctive name, yada yada yada. Generic name, but what's this? Name and arms clause. The popular name of an English law for the clause sometimes inserted in a will or settlement, don't have to be a will, by which property is given to a person for the purpose of imposing on him the condition that he shall assume the surname and arms of the testator or settler. Again, don't have to be dead. With the direction that if he neglects to assume or discontinues the use of them, the estate shall devolve on the next person in remainder, and a provision for preserving contingent remainders. So, if you were made a party to a deed as an infant, they said, look, we have this prepaid estate for you, here it is. And when you turn 21, you're going to have to take on the surname and arms of a settler, whoever that is, before you can have this. And if you don't do it, we're going to give it to the next person in remainder, a provision for preserving contingent remainders. In other words, we're going to put it back into the kitty. Right? But until then, as long as you do this, it's yours. Now, of course, as an infant, nobody read this deed to you. It's not been read. And the deed, I believe, is part of the record. And if we go get the record, it's going to tell us what we're supposed to be using as a surname and our arms, which is your armorial bearings. It's like your shield. It's not a gun. It doesn't have any lead coming out of the end of it. So we can have our estates. Settler, a grantor or a donor in a deed of settlement. Right? So I think it's the church that funded the account. Right? I think the Catholic Church did it. The grantor or settler, and to take advantage of this, we need to take the name of the Lord Jesus Christ and His sign, which is the cross. That's our armorial bearing. We'll find out when we get a look at the record. And furnishes the consideration for the creation of a trust, though in form the trust is created by another. So the settler just puts it in, somebody else is creating the trust, and the settler is putting in the res for the trust. Estates, the settlement of an estate consists of, because this is what we have, that's what your all caps is an estate. It's not a trust. A trust is a contract. It's an estate held in trust, where the res is put in by the grantor, the trustee holds a legal title, and the beneficiary is supposed to have the beneficial interest of what's in the trust. But because the trustee holds the legal title, unless the trustee acts lawfully, legally, reasonably, he has a legal title, and in law, as long as you have the legal title, you're the owner. Which is why you need to go to the Court of Chancery to say, hey, they're using law, a statutory law, as an instrument of fraud. It's an estate held in trust. It's not a trust. Trust is a contract between a grantor and a settler, or between a grantor and a trustee. The settlement of an estate consists in its administration by the executor or administrator carried so far that all debts and legacies have been paid, and the individual shares of distributees in the corpus of the estate, or the residuary portion, as the case may be, definitely asserted and determined, and accounts filed and passed, so that nothing remains but to make final distribution. Settlement in reference to decedent's estate includes a full process of administration, distribution, and closing. Right? That's a reference to a decedent's estate. Well, that's just one kind of an estate. I was given an estate. I just don't have access to my estate. Surname. The family name, the name over and above the Christian name. Now, what does it mean to be over and above the Christian name? I'm not really sure what that is yet. The part of a name which is not given in baptism. That's interesting. The part of a name which is not given in baptism. The name of a person which is derived from the common name of his parents. Right? Didn't say your father's name, did it? Is that the common name? I couldn't find a definition for common name. What does that mean? The last name, the name common to all members of the family. Well, I guess then it is my father's name. Is that the surname? See, Rytlewski, S-K-I, here. Funny story, when I was stationed in the Army, I was in Germany, and I went to the library at the post to get a library card. And the librarian there, looked at my ID and said, Rytlewski. I know, I have a friend named Rytlewski. From Poland. But he spells his with a Y, not with an I. Why is yours with an I? Everyone in Poland is with a Y, not with an I. Well then, come to find out that a lot of people's names were changed when they got to, when their ancestors got to Ellis Island. Right, so they changed my surname. So Rytlewski with an I really isn't my surname. It's a fictitious name. Christian name. The baptismal name, as distinct from the surname, the name which is given one after his birth or at baptism, or is afterwards assumed by him in addition to his family name. Such may consist of a single letter. A single letter could make up your Christian name. Fictitious name. A counterfeit, alias, feigned, pretend name taken by a person differing in some essential particular from his true name. Alright, now in parentheses, consisting of Christian name and patronymic. So your true name is your Christian name and patronymic, right? But the fictitious name doesn't have that, with the implication that it is meant to deceive or mislead. See also alias. And what is this patronymic? Component of a personal name based on the given name of one's father, grandfather, or even earlier male ancestor. A component of a name based on the name of one's mother is matronymic. Each is a means of conveying lineage. Are still used, including mandatory use in many places worldwide, yada yada yada. Except now they're called patronymic surnames. Patronymic surname. A patronymic surname is a surname originated from the name of the father. Different cultures had different ways of producing surnames. For example, early Welsh surnames were the result of anglicizing of traditional Welsh naming system, which may have included references to several generations. So somebody, son of somebody, son of somebody, right? Boom, boom, boom. They had this lineage. That was a surname. It wasn't like Rytlewski. It was like Robert, son of Delbert, grandson of Bernard. Something like that. So, right, do I have a name like that I'm not familiar with? Because I'm using Rytlewski, and that's really a family name. It's not my patronymic surname. And then you go to the Bible, and, when they show these lineages of people that go on and on and on, son of, son of, son of, son of, son of, right? That's a surname. Apparently. Full name, the first, middle, and surname of a person. So the question is, are we walking around right now with the proper surname, or is that surname because, remember, up here in this name and arms clause, we have to use the surname of the settler. I'm not sure who settled it, because, right, who put it into the account? That's the settler. Generic name, legal name under the common law consists of one Christian name and one surname. And the insertion, omission, mistake, a middle name or initial is immaterial. The legal name of an individual consists of a given or baptismal name, usually assumed at birth, and a surname deriving from a common name of the parents. So it could be that our surname is our father's name and mother's name, surnames together. Don't know yet. More on the name thing here in a little bit, but now we're going to get to a strange kind of name called a street name. Anybody ever ask you what your street name is? Securities held in the name of a broker instead of his customer's name are said to be carried in a street name. I think this is happening to us all the time. This occurs when securities have been bought on margin or when customer wishes the security to be held by the broker. The name of a broker or bank appearing on a corporate security with a blank endorsement by the broker or bank when security can then be transferred merely by delivery since the endorsement is well known. Now remember, a court is just a bank. And so if the court's holding our paper, they're holding our securities, right? That instrument I had, that's really just a copy of a security. It's my title. It's the owner's certificate of title. That's my security. That, hey, I'm the owner. Street name is used for convenience or to shield identity of the true owner. Go figure, right? Well, we're not going to tell you it's your property. We're going to put it in a street name. When you buy securities through a brokerage firm, most firms will automatically put your securities into a street name, not into your name. We're going to put them in somebody else's name. This means your brokerage firm will hold your securities in its name or another nominee and not in your name. But your firm will keep records showing you as the real or beneficial owner, of course. You will not get a certificate, but will receive an account statement from your broker on at least a quarterly or annual basis showing your holdings. Well, you should. What if they never sent them to you and you didn't even know you had this? Street name securities in the United States, street name securities or nominee name securities are securities of companies which are held electronically. Again, your all caps is a company, it's an estate, it's all sorts of things, which are electronically in an account of a stockholder, bank, or custodian, similar to a bank account. The entity whose name is on that account as the owner is known as the nominee owner, but the entity has ownership rights, and the entity has ownership rights in the security. So the nominee owner's name is on the account. Well, that makes him the owner. It doesn't matter that it's supposed to be your property. This is a trust. We're really talking about a trust here. The nominee owner, that's who the trustee is. The legal title goes to the trustee. And there's a beneficial interest or beneficial owner. The nominee owner, in turn, passes on those ownership rights, which are ultimately passed on to the final actual shareholder or bondholder. Right? It didn't say to you, because are you holding the share or the bond? Not necessarily. The actual shareholder or bondholder to whom the rights are ultimately passed is referred to as the beneficial owner. And we don't have them. We just have copies. They're in the court. I'm believing. In the U.S., CD and Company, a nominee of the Depository Trust Company, everybody who does any research on birth certificates and stuff knows that the Depository Trust Company is typically the largest stockholder of the company. In the U.S., where CD and Company is the street name holder, therefore, all beneficial rights, such as voting rights and dividends, flow first to the nominee, CD, and then are passed onward and ultimately to the beneficial owner. Sure they are. The popularity of nominee accounts has increased rapidly since the introduction of the internet. Okay, holding methods. Street names is one of three ways of holding securities. The other two are stock certificates and as a direct registration, personal crest account in the UK. All right, we want to get it from this nominee to a direct registration. I'm thinking. Or have the certificates. Nominee accounts make paperless telephone and internet trading possible with faster settlement periods and lower commissions than certificate deals. They often enable domestic small investors to gain access to derivatives such as warrants. And everybody thought a warrant was just to arrest you. No, you got all sorts of warrants and contracts for differences. To exercise various types of an order and to buy, share, and margin, there is no risk of loss, damage to the certificate. It is also possible to obtain an instant valuation of the whole portfolio, and that is the key right there. Because when you go claim your estate and you get this done right, the book's got to balance by 6, no later than midnight. How are they going to do that? Had to be some kind of way to instantly value the portfolio. I need an instant valuation of all caps Robert Allen Rytlewski right now, please. What is he worth? On the negative side, the shareholder is tied into one stockbroker as opposed to a certificate holder who can pick and choose stockbrokers every time they deal. I don't want to deal anymore. I want to cash in my shares. If the stockholder is unhappy with their nominee's service, they have to arrange to transfer the shares out, which can be a lengthy process for which there is usually a charge. The lack of a share certificate can also make it difficult to use shares as collateral for a loan. Because the shares are held in the name of the stockbroker and not you, or the name of the bank, the name of the beneficial owner does not appear on any share register. Nobody knows you exist. This means that dividends, shareholder perks, company reports, details of corporate actions, and other communications are sent to the stockbroker rather than the beneficial owner. This is the mail you're not getting. This means that dividends, you're not getting the dividends, you're not getting the shareholder perks, company reports, details of corporate actions, none of this. It's going to the stockbroker instead of to you. And that's why they don't want to give it up. They're not stealing your property, they're just taking your perks. They're building that estate up. They get more money. The extent of methods for handling this can vary considerably between brokers. Failure of a stockbroker or bank to pass on shareholder right and communications to the beneficial owner is one of the major complaints against nominee accounts. That's a major reason why activist shareholder organizations such as the United Kingdom Shareholders Association are opposed to their use. During 2006, the UK government passed an amendment to the Companies Act, which gave nominee shareholders more rights. Well, go figure. They're going to give the nominee shareholders even more rights. The anonymity of nominee accounts does benefit individuals who wish to hold shares in controversial companies. This was proved useful in situations where investors on share registers, again, you're not listed anywhere, so not talking about you, have been threatened by animal rights protesters, because you are an animal, you have an animal, right? You're moving this animal through God's kingdom, such as Huntington Life Science and GlaxoSmithKline. As a consequence, the protesters have been known to intimidate the employees of the stockbrokers instead in order to try to force companies to stop handling the shares. And back to the name and arm clause. So anyways, that's what a street name is. I haven't done a lot of research on it yet, but from what I'm reading right here, this is what's happening to us. It's like a bank account, except your name isn't on it. It's in somebody else's name. Makes them the legal owner. You're supposed to have beneficial interest, but it isn't getting to you because they're not sending you the mail. In fact, you don't know this thing exists. And all that could go away when we because of the name and arm clause, which is another way they could have done it. And this was just a couple of examples of this going on right now. A disgruntled son of a baronet has lost his latest appeal over the sale of the family's ancestral home. Philip Howard had claimed his father, Sir John Howard Lawson, had broken the terms of his grandfather's will, so had no right to sell the castle. The son wanted it. It was a great place to take your pickup girls to. However, the 3 judges in the Court of Appeal dismissed the challenge by Mr. Howard against a ruling by some judge of London a year ago, and backed her interpretation of an eccentric clause in the 1930 will. The case rests on the application of archaic terms of will executed by great-grandfather Philip John Canning Howard. Philip John Canning Howard. See, he's got a couple of names. Which instructed all subsequent heirs to change their surnames to Howard and adopt the family coat of arms. To satisfy the clause, the beneficiary also had to establish his legal right to do so by an application to the College of Arms, all of this before the deadline set in the will. These are the clauses that could be in a contract. You had to change your surname to Howard. And who was this guy? Philip Howard had claimed his father, Sir John Howard Lawson, had broken the terms of his grandfather's will. All subsequent heirs to change their surname to Howard. Now, did he do that? Sir John Howard Lawson. Philip Howard claimed that Sir John never satisfied the name of arms clause since his petition. Right? So, yeah. Sir John, the father, hadn't changed his name to Howard the way he was supposed to. Philip Howard claimed that Sir John never satisfied the name arm clause since his petition to the college is not lodged until after the year allowed him had expired. He lost his claim in the High Court in 2011. Says that Alan Dickens, the Court of Appeals, has not only upheld the judge's decision that there was no independent obligation to take and use the Howard name within the year, but also direct address the question I raised as to whether the application for the College of Arms was sufficient to comply with the clause, whether the petition to the royal license to use the arms should have been presented within a year. It has drawn a clear distinction between the obligation to merely apply, as required by the will, and a requirement to present the petition, words not used in the will, and seems doubtful whether the Supreme Court would interfere with that. Okay, so basically they said, because this guy did eventually do it. Now, so let's go back and look. We got this is the grandson who's bitching about it because his dad, this guy, he sold the farm. Right, but he's got Howard in there, Sir John Howard Lawson. So he must have been Sir John Lawson before this, and then he put Howard in. Because Sir John Canning Howard, which instructed all subsequent heirs to change their surname to Howard and adopt the family coat of arms. And the boy was saying the dad hadn't done it soon enough. He hadn't done it within the year, and the judge said, no, it's okay, he did it soon enough. Apparently, an ancient a tradition for expecting your heir to take your name and coat of arms has led to a modern legal dispute over fortune, says somebody. Occasionally the press enjoys covering legal cases which sound like they come straight out of the Dickens novel. They concern matters such as chancel repairs or equitable doctrines or names and arms clauses. Equitable doctrines, that's what we're trying to use. We want to use the can't think what they're called. Equity, common law. Oh, they got a list of them. I can't think what they call them. It'll come to me. At one time, it was relatively common among gentry to include names and arms clauses in a will. This was done to preserve a grand old surname throughout the ages, and provided that in order to inherit assets under the will, the beneficiary had to take on the name and arms specified in the will. Often the entitlement was not an absolute one, but a life interest under an old-fashioned trust. The issue in the Howard case was not the interpretation of the modern will. The will in question was late Philip John Canning Howard's. He had died in 1934. The question is whether his great-grandson had complied with the terms of the names and arms clause. In other words, had within a year of becoming entitled to the Corby settled estates adopted Howard name and the Howard arms. To add additional intrigue, the claimant in the case was Sir John's own son, Philip William Howard, the great-great-grandson of the testator. His case was that if his father had not complied with the name and arms clause, then his father would have forfeited any right to the Corby settled estate, which would instead be held in trust for him. And so I believe we have this trust sitting there for us, and we need to go and see what is in the record that we're supposed to be using for our surname and our coat of arms. The key factor was that during 1961, Sir John began using the name Howard, and in July 1961 he applied to the College of Arms for permission to change his name and arms to Howard. The college then had to forward the application to the Home Office to establish family pedigree and prepare the petition for the Queen. In fact, when through the royal license was not issued until 1962, outside a 1-year deadline, despite the fact the case raked over matters some 50 years ago, it had real importance for the protagonist. Similarly, there are cases involving chancel repairs which are of real relevance. Take that of Mr. and Mrs. Wellbank, 2003, were ordered to pay a $100,000 bill for repairs of a church 100 miles from their home. In the case, the law lords described the law as archaic and unsatisfactory, but were powerless to prevent the claim by the church because the liability of the chancel repairs had been attached to the property. Not so interested in that. Coat of arms. Name changes. The change of a name may be evidenced by a deed poll prepared by an officer of arms and entered into the official records of the College of Arms. The change of the name is gazetted in the London Gazette. The person whose name is changed need not be a person entitled to the arms. A deed poll which has been prepared elsewhere may also be entered into the college registers. By royal license. A surname may also be altered or removed or changed by royal license. Arms granted to one family can only be transferred to another person, not in legitimate male line of descent from the original grantee, by means of a royal license, followed by the exemplification of the arms. A royal license is usually granted on the advice of the Secretary of State for Justice, where the petitioner is required by clause in a will to assume the name and arms of the testator in order to inherit the legacy. But voluntary applications are also obtained. So when a cop stops you and says, license, registration, and insurance, what, the royal license that changed my surname? Is that what you want? registration. That certificate of title you get is your owner's certificate of title showing that the vehicle has been registered, because the original title, whatever they call that thing that comes from the manufacturer's, whatever it is, that's the title. Your certificate of title is your registration. That's the registration to the car. And it shows that you're the owner. It's the owner's certificate of title. You're not an operator. You're the frickin' owner. And then as far as the insurance, I believe when we get this all straightened out, right, you go out and you get business insurance for your business, your all caps name, and it will cover, it'll be liability insurance, and it will cover everything that you're involved in. But a royal license is usually granted on the advice of the Secretary of State for Justice, where the petitioner is required by a clause in a will to assume the name and arms of the testator in order to inherit the legacy. Petitions of such royal license is drafted by an officer of the arms for the signature of the petitioner. It is then submitted on his or her behalf by the officer of arms to the Ministry of Justice, who forward it to Buckingham Palace. As a result, royal license and any subsequent explication of arms must be recorded in the official register of College Arms to be valid. The law of arms, relation between heraldic usage and the law of arms. It must be carefully considered that some rules are heraldic usage. Some other rules are legal rules. Legal rules can be dealt with in courts of law, but usages cannot. The extent to which the rules are legal rules, respectively heraldic usage, varies. In legal systems where there are state professional heraldic organizations, the rules are legal to a large extent. Where heraldry is seriously dealt with, both usage and legal rules are of course applied. Therefore, in many cases, no problems will arise, since all rules and usages are followed. When it occurs that something is done in an unconventional way, it is important to pose a question: is this contrary to legal rule, or is it only inappropriate in heraldic sense? In the first case, where the contrary to legal rule, it can be tried in a court or by an authority. In the second case, it cannot be tried in a legal way, but can be criticized by heralds and heraldess, yada yada yada. Relationship between names and arms. It has been said before, but needs to be said again. The fact that two persons have the same name does not mean they have the same family arms. They are similarities between names and arms. They both identify persons, and in many legal systems, they are both legally protected in similar ways. However, many unrelated families can have the same name, but unrelated families should still have different arms. It is therefore inconvenient that many armories, printed as well as on the internet, show coats of arms and only connect them to family name, which sometimes is a common one. It ought to be said in such cases who adopt or granted the arms, and when, if that information is given, it can be more easily found who the arms are and are not. Okay, so the arms are your family crest, basically. Furthermore, names and arms can be transferred to younger generations differently. Names and arms are mainly transferred through birth. You get a right to your family's name and arms when you are born. However, many European countries, right of name can be transferred from the mother, not only the father. Where the two get married, they are choose, yada yada yada. So, relationship between trademarks and arms. When intellectual property rights in the late 19th century became more important, the question arose how arms were to be protected against use as trademarks. The Convention of Paris 1833, revised in 1967, protects arms and emblems of states against use as trademarks. Okay? So whoever this guy is, somebody, the earliest writer on the law of arms. He was born in 1313, died 1357, was one of the most famous jurists of the 14th century, belonged to the school of commentators or post-glossarators. His something or other is the first treatise on the law of arms, is now considered that somebody wrote the first legal part of the book, and that his son-in-law wrote the second part, which does not concern law, but heraldic usage. The right to bear arms. Everyone had a right to have a name. Therefore, everyone, according to Bartolus, had the right to bear arms. It has nothing to do with a pea shooter. The name and arms have the same function. They identify people. It is not prohibited to assume arms. However, a grant of arms had certain advantages. There is no legal protection of arms as such, but if someone has injured when someone else took his arms, the original bearer of the arms could lodge a complaint in the court. Injury was, for example, when the use of arms caused confusion among people. Thus, arms were not generally protected. Bartolus' famous example was, if an Italian and a German have the same arms, it is allowed, since because of the distance it cannot cause confusion. Yeah, well, those days are long over. The succession of arms was, according to Bartolus, agnatic from the father. That means that everyone, woman and men, could use their father's, but not their mother's arms. The foundation of this principle is found in something else. I wrote that there is no distinction between arms and trademarks. They were, according to Bartolus, governed by the same rules. One exception, however, rule of succession. A trademark should belong to the factory, not to the family. United Kingdom, England and Wales, Northern Ireland, right to bear arms. The right to bear arms. I think that's in the Constitution somewhere, or Bill of Rights or something. Under the jurisdiction of the Court of Chivalry, it was not acceptable that everyone has the right to bear arms. The condition for having arms is that the person is a gentleman. That scares me. Or, as it has been expressed since 1741, is eminent. That's different. Is eminent. Thus, eminent men, eminent women, eminent corporate bodies may bear arms. To be eminent, a certain profession or social standing is required. An eminent person cannot by himself assume arms. There are two possibilities to get rights of arms. You have the right to arms by birth or by grant. If a person assumes arms, be he eminent or not, the arms have no legal protection. Right to bear arms by birth or by grant makes you eminent. Now, an eminent person can, just like an eminent corporation, can claim eminent domain. Go look up eminent domain. You'll see that, that's what a eminent corporate body can do, because really that's all a state is. It's just a corporate body. It's got a constitution. It's a corporate body. It's a political subdivision. It's a political subdivision of a nation. The arms are legally protected once they're granted by the crown, or if they are used since time immemorial. So, Christian arms could be the sign of the cross. Grants are issued by kings of arms of the college, are issued by the kings of arms of the College of Arms. A grant gives the grantee a legal right to the granted arms. User since time immemorial is paradoxically counted back to 1066, but is presumed to be fulfilled when a shorter period of use beyond living memory can be shown because of the heralds' visitation and registers of grants. Difficult to know to now. It is difficult now to prove a right to arms that way. A person therefore has a right to his father's arms. Name and arms clauses are clauses within a will which is a condition stipulated that the beneficiary uses the testator's name and arms. The will in itself gives no right to the arms, and the condition to be fulfilled only through a grant from the crown. Okay, So, crazy stuff. That was pretty much what I wanted to talk about. Right to bear arms. Don't have lead coming out of it. It's not a pea shooter. It's an memorial bearing. It's some kind of sign. Infants are parties to deeds. In that deed, it probably says, yeah, you're going to take this surname and here's your sign. And in a street name, that's where they're hiding through a nominee your property. And anytime they want to muddy up the water, they just have a little fire, or they put an ad in the paper. Hey, you need to come in and fill out a petition to say you're the owner of the property. If not, we're going to put one in that says we are. And land registration, they took the titles, they put them in a drawer, they came up with these certificates of title, they put the original in a file in the Register of Titles office, they give you the owner certificate of title. That's like the document I showed earlier, or it's like your car title, but you don't have the one to your real estate, and that's the problem. And our power player of the day was the state of North Carolina, clerk of the Superior Court. Why? Because they are ex officio judge of probate. They can do lots of things for you. They can take your petition. They can take your petition, especially if you're in your birth county, and say, I would like to order the record for your all capital letter name. And let's see what's in the file. And again, if you can, please donate. It's getting close to the end of the month. I don't like to worry. I don't usually worry. God always finds a way, because good people donate me money. I don't like to work for it. I like to research for it. So I'm doing the best I can. If you think this is useful, please send me a donation. Appreciate it. You all have a great night. We'll see ya. Bye-bye.